National Bureau of Investigation shall, among others, be responsible for the efficient detection and investigation of crimes and other offenses against the laws of the Philippines, upon its own initiative and as public interest may require, rendering assistance whenever property requested in the investigation or detection of crimes and other offenses, and coordinating with other national and local police agencies in the maintenance of peace and order. Under RA number 157 and BI undertake investigation of crimes and other offenses against the law of the Philippines upon its own initiative and as public interest may require. Number 2, to render assistance whenever properly requested in the investigation or detection of crimes and other offenses. Number 3, to act as a national clearinghouse of criminal and other information for the benefit use of all prosecuting and law enforcement of the Philippines, identification records of identifying marks, characteristics, and ownership of possession of all firearms as well as test bullets fired therefrom. The PAO shall independently discharge its mandate to render free of charge legal representation, assistance, and counseling to indigent persons in criminal, civil, labor, administrative, and other quasi-judicial cases. The exigency of the service, the PAO may be called upon the proper government authorities to render such service to other persons, subjects to existing laws, rules, and regulations. The PAO shall extend free legal services to an applicant who is indigent and cases is meritorious. The Philippine government has various agencies purposely to address the different issues and concern nationwide to maintain orderliness and solve problems. However, the National Bureau of Investigation and Public Attorney's Office, even though has its distinct duties and responsibilities but have unified objectives for the betterment for Filipino citizens. Moreover, the National Bureau of Investigation and PAO are both solving criminalities across the country, implementing and executing laws in our 1987 Philippine Constitution. Legal basis. Rules of Court 21 Subpoena. Section 1. Subpoena and subpoena duces tecum. Subpoena is a process directly to a person requiring him to attend and testify at the hearing or the trial of an action or at the learning of the trial of an action. At any investigation conducted by competent authority or for the taking of his disposition. It may also require him to bring with him any books, documents, or other things under his control, in which case it is called a duces tecum. 1 AR 23 Section 2 by whom issued. The subpoena may be issued by the court before whom the witness is required to attend. Sample case, Stalpa or Swindley. Article 315 of Revised Penal Code. First Division, GR number 225753, October 15, 2018. Jose Paulo Legaspi and Rivera, Petitioner versus People of the Philippines, Respondent. GR number 225799, October 15, 2018, Victor Daganas Handok, Petitioner versus People of the Philippines, Respondent. Petitioner Jose Paulo Legaspi, Rivera, and Victor Daganas E. Handok, collectively the petitioners assail through these consolidated petitions for renew of certiorari. Under Rule 45 of Rules of Court, the decision dated January 21, 2016, and the subsequent resolution dated July 13, 2016 of the Court of Appeals and CAJR CR number 36404 Respondent through the Office of the Solicitor General OSG filed its comment on the consolidated petitions to which Legazpi interposed a reply. On September 6, 2017, the court denied the consolidated petitions for failure to show reversible error on the part of the CA as to warrant the exercise of its discretionary appellate jurisdiction. Legazpi and Daganas timely moved for reconsideration and urged a review of the denial of their petitions essentials on the ground that the information under which they were charged was fatally defected and negates the crime charged therein. The OSG sought the denial of petitioner's motion for reconsideration. Legazpi and Daganas were charged with the crime of stapa, committed under Article 315, Paragraph 1b of the Revised Penal Code, RPC, in an information which reads: The undersigned State Prosecutor 2 of the Department of Justice in his capacity as the acting city prosecutor of Pasig City hereby accuses Legazpi and Daganas of the crime of estapa under Article 315, Paragraph 1b of the RPC committed as follows. That on or about November 15, 2005 in Pasig City and within the jurisdiction of this honorable court, the above-named petitioner, conspiring and confederating together and helping one another, did then and there willfully and lawfully defraud Fong Heng Kit in the following manner to wit. The said petitioners, with the abuse of confidence, induced Fong Heng Kit to invest at iGene portal, and the latter invested and in fact deposited the amount of 9.5 million pesos into the account of iGene portal. Once in possession of said amount, the said petitioners, with abuse of confidence, misappropriated, misapplied, and converted the said amount to their own and personal use and benefit, to the damage and prejudice of said Fong Heng Kit in the aforesaid amount of 9.5 million pesos. Stapa grounds: abuse of confidence, false pretenses, through fraudulent means. The accused defrauded another by abuse of confidence or unfaithfulness, deceit or false pretense. Letter B. There is a damage or prejudice capable of pecuniary estimation. Stapa is punishable by imprisonment up to 20 years. Article 315 of Revised Penal Code. Stapa through abuse of confidence. Letter A. By altering the substance, quantity, or quality of anything or value which the offender shall deliver by virtue of an obligation to do so, even though such obligation be based on an immortal or illegal consideration. Letter B. By misappropriating or converting to the prejudice of another money, goods, or any other personal property received by the offender in trust or on commission, for administration, or by denying having received such money, goods, or other property received by the offender. Misappropriation or denial cause damage to the offended party. Letter C. By taking undue advantage of the signature of the offended party in blank and any writing any document above such signature in blank to the prejudice of the offended party or any third person. Fraudulent acts: by using fictitious names, by falsely pretending to possess power, influence, qualifications, property, credit, agency, business, or imaginary transactions, by means or other similar deceits, by altering the quality, fineness, or weight of any pertaining to his art of businesses, by pretending to have braided any government employee without prejudice to the action for calumny which the offended party may deem proper to bring against the offender. Jurisprudence. finding petitioners guilty of the crime of estafa and disposed as follows. Wherefore, premises considered judgment is hereby rendered, finding the accused Legazpi and Daganas guilty beyond reasonable doubt of the crime of estafa, penalized under Article 315, Paragraph 1b of the RPC, without any aggravating circumstances, and are accordingly sentenced to suffer the intermediate penalty of imprisonment ranging from 4 years and 2 months of prison correctional, as minimum to 20 years of reclusion temporal as maximum, and to indemnify private complaint Fong Heng Kit in the amount of 9,500,000 as well as to pay the cost of suit. Ruling of the court. We find merit in the motion of reconsideration, and accordingly, the court reconsiders its resolution dated September 6, 2017. Criminal fraud resulting to damage capable of pecuniary estimation is punished under Article 315 of the PRC. In general, the elements of estafa are: first, that the accused defrauded another by abuse of confidence, by means of deceits, and that damage of prejudice capable of pecuniary estimation is caused to the offended party or third person. Invariably, unlawful abuse of confidence or deceits is the essence of estafa. In particular, estafa through misappropriation is defined and penalized under Article 315, Paragraph 1b of the RPC as amended by Republic Act Number 10951, which provides Section 85, Article 315 of the same Act as amended by Republic Act Number 4885, Presidential Decree Number 1689, and Presidential Decree Number 818 is hereby further amended to read as follows. Article 315, Swindling Estafa. Any person who shall defraud another by any of the means mentioned herein below shall be punished by: first penalty, the penalty of prison correctional in its maximum period to prison mayor in its minimum period if the amount of the fraud is over 2,400,000 pesos but does not exceed 4,100,000 pesos, and if such amount exceeds the latter sum, the penalty provided in this paragraph shall be imposed in its maximum period, adding 1 year for each additional 2 million pesos, but the total penalty which may be imposed shall not exceed 20 years. In such cases, and in connection with the accessories penalties which may be imposed and for the purpose of the other provisions of this code, the penalty shall be termed prison mayor of reclusion temporal. With unfaithfulness or abuse of confidence, namely, by misappropriating or converting to the prejudice of another, money, goods, or any other personal property received by the offender in trust, or on commission or for administration or under any obligation involving the duty to make delivery of or to return the same, even though such obligation be totally or partially guaranteed by a bond, or by denying having received such money, goods, or other property. The elements of estafa through misappropriation under Article 315. Paragraph 1b are: the offender receipt of money, goods, or other personal property in trust or on commission or for administration or under any other obligation involving the duty to deliver or to return the same. Letter B. Misappropriation or conversion by the offender of the money or property received or denial or receipt of the money or property. Letter C. The misappropriation, conversion, or denial is to the prejudice of another. And letter D. Demand by the offended party that the offender return the money or property received. To establish the first element of STAFA under Article 315, Paragraph 1B, the CA focused on an acknowledgement receipt executed by Legazpi to show that the later ended received the amount of 9,500,000 from private complainant. This observation is, however, inaccurate. For one Article 315, Paragraph 1B requires proof of receipt by the offender of the money, goods, or other personal property in trust or on commission, or for administration or under any other obligation involving the duty to make delivery or to return the same. In other words, mere receipt of the money, goods, or personal property does not satisfy the first element. Conclusion. Therefore, the 1987 Philippine Constitution, implemented and executed with their NBI or PAO and other government agencies nationwide, have its full power to compel anybody with accordance of the law, because no one is above the law. Ignorance of the law excuses no one, meaning, even though you have it already or not, still, the law shall implemented and executed. Going back to the question, can NBI or PAO compel you to appear before their office, before them, in case a complaint is filed against you? My answer is absolutely yes, by issuing subpoena. Furthermore, both NBI and PAO have the full power to compel anybody to appear before them with the Accordance Rules of Court 21 Section 1. Your appearance does not mean you are guilty or put you to prison directly, but rather, there might be a series of questioning regarding the case being filed. I will discuss first NBI. You will be charged a case, especially crime against public officials like President and Vice President of the Philippines, Senate President, Speaker of the House, House of Representatives, national threat and human trafficking. While in PAO, those allegedly committed a crime not included the above-mentioned personalities, meaning just a normal citizen of the country. The NBI and PAO will advise to execute a counter-affidavit with the assistance of either private lawyer if you have enough budget. If you are indigent, go to PAO, which is free of charge. However, your appearance in NBI and PAO in order for you to answer those accusations and defend yourself with assistance of your chosen lawyer executing a counter-affidavit answering the alleged charges either in prosecutor's office or any courts. For instance, NBI or PAO issued subpoena for your appearance. Come immediately. Don't be afraid and hesitant. Face it to clean your name. Your resistance of coming is tantamount to guilty. Moreover, perpetual resistance may create another problem. Certainly, the NBI or PAO may file so-called obstruction of justice and contempt of court, evade more complicated charges. I reiterate, come show yourself to competent authorities. Recommendations. In case NBI and PAO send you a subpoena or summon and ongoing trial, here are my recommendations. Number 1, come immediately, face the charges. Number 2, ask help either private or public attorney's office lawyer. Number 3, do not run always as fugitive. Number 4, attend hearings regularly. Number 5, be cooperative with your lawyer. Number 6, be respectful during interrogation. Number 7, do not harass your opponent or complainant. And lastly, provide essential document when it is needed.